Welcome to this Holmquist Gardiner Quick Insights video on indemnity clauses in commercial leases. As always, this video is for informational purposes only and should not be a substitute for, nor is it intended to be, actual legal advice. If you require legal advice, please seek a law firm, whether it is Holmquist Gardiner or anyone else. Key components of any commercial lease are the indemnity clauses, which establish the risk-shifting behavior of any incidents that may occur during the lease and who is responsible for the costs associated therewith. Indemnity clauses allocate responsibility for claims, losses, and property damage associated with the property. A good indemnity clause will determine who bears the financial risks associated with such claims, losses, or lawsuits in connection with the leased premises. In practical terms, an indemnity means that if the landlord suffers losses or is being sued by a third party pursuant to any actions by a tenant relating to the lease, then the landlord could turn to the tenant to pay out any losses or cover any charges relating to such suits, often including attorney's fees. Most commercial leases will impose broader indemnity obligations on a tenant than on a landlord. This is because the tenant is the party actually occupying the premises. While a tenant will commonly only indemnify the landlord for their use, occupancy, or business operations at the premises, a landlord typically will only indemnify the tenant for any gross negligence or willful misconduct of the landlord. Having an indemnity provision does not automatically equate to a responsibility of the indemnitor to carry insurance. So, it is important to address your insurance coverage needs separately within the lease. Indemnity clauses are not academic. They control real dollars and real lawsuits. Understanding the process and indemnity provisions you have in your lease is important before signing or attempting to enforce any commercial lease. Again, this video is for informational purposes only and is not a substitute for, nor is it intended to be, actual legal advice. Thank you for joining us here at Holmquist Gardiner for our quick insights.